Right, Black is in custody.
They should never go out of jail despite the way something was.
No, I can't hear you. You know, it's locked up.
Probation didn't put him out of jail, so.
Oh, okay. Please reset that. Probation notified. They were supposed to do that. First. Okay. Mr. Abbott, we'll reset him. It's by Mr. Black, June 1st to 8:30.
Thank you, Ron.
Nancy Christie.
Mr. Austin.
Ms. Arkansas. Okay. We're running Cowden.
Yes, Judge.
We're running Roberts.
Yes, Judge.
Okay, please, sir. Who's this on Zoom? Okay. That's what she does at PCC with. Is that green screen?
Yes.
Okay. Right, you can start the first exam.
Mr. Cowden needs brother.
Mr. Green is here.
James is here with Mr. Gailey.
On the record of the matter of the people of the state of Michigan versus Brandon. Daily trial number 23-00850. Council parents.
Brian Ring on behalf of the people.
Good morning, Your Honor. Gidget James on behalf of Brandon Daly, who is president of G16 Days on the right.
Just trying to find it. Please the date and the time that was set for a preliminary examination. And there's a request to adjourn.
There is, Your Honor.
Your Honor, it was defense's request. We just subbed in on this case late Tuesday afternoon, just allow us to receive discovery before we move forward.
Okay, I see, I signed it. Should for days as well. Okay, was this a conflict counsel or did he just retain?
He retained.
Okay, Mr. Daly, I understand that you have the right to have a preliminary examination within 21 days of your arraignment.
Yes, ma'am.
You retain a counsel, private counsel, after being appointed, court-appointed counsel. Are you willing to waive your 21-day timeline so that they can represent you and get discovery and help you formulate your defense? Okay, so we'll get your new date. June 1st at 9 a.m. Does that date work for you?
June 1st at 9 a.m. does work, Your Honor.
Request at 9 a.m. I said at 3,000 personal recognizance that will continue. Any additional matters to the record?
Nothing about the people. Thank you, Your Honor.
Nothing for defense. Thank you, Your Honor.
So you're also get you a copy of your notice to appear. Okay. All right, thank you. Turn on one of these ones for me. Actually, turn this one because that one I think. That's still recording. Thank you.
Yeah. my pleasure.
We're gonna submit.
Weird. Yeah, okay. I'm good with that. I believe we're good with Tariq Stevenson.
Right here.
Oh, sorry, I believe we're good with Tariq Stevenson.
What, you said you're good?
Yeah, I don't have anybody here.
Oh, we're on the record in the matter of the people of the state of Michigan versus Tariq Malik Stevenson, file number 23-01071. Council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. John Abbott with the Public Defender's Office representing Tariq Stevenson. He's present, staying to my right.
Mr. Stevenson, today was the date set for a preliminary examination, and the people do not have the necessary witnesses to appear, correct?
That's correct, Your Honor, when I proceed the same.
So this matter will be dismissed without prejudice. So that means that the people have the right to reissue the charge against you if the necessary witness appears and is ready to proceed, okay? Have a question at this time?
Okay, thank you, Your Honor.
The defense, thank you.
If you hang tight, we'll get you a copy of your dismissal.
And then one here
Okay.
for Calvin.
Is this the same or different cases?
The same case.
Oh.
Sign real quick, Judge, and I'll be right back.
That's all right, you know, it's the night style. Mr. Starks is here on here.
Correct, Your Honor.
Mr. Green. On the record of the matter of the people of the state of Michigan versus Joseph Michael Atkins, file number 23-01286, council appearance.
Brian Ring on behalf of the people.
Thank you, Honor. Vince Green, on behalf of the defendant, Joseph Atkins.
It was the date and the time that was set for preliminary examination. I have a note here that we're supposed to treat today as another probable cause conference, which means we would need to. Looks like you waited 21 days last week before Judge Board. Is that correct?
That's correct, Your Honor. He was denied, he was informed that he was denied a public defender at the PCC, and we're just gonna treat this as a PCC just to make sure, just to get a status update on where he was getting counsel or if he had it or not.
So it looks like he's retained Mr. Green, correct?
That is correct, Your Honor. Mr. Atkins met with me, I think it was Tuesday. I spoke with his father on the phone. They will be retaining me either later today or tomorrow. Expect to retain and file. We are getting our paperwork together to file our appearance.
How is he doing JIS if he's not filed an appearance? I said attorney filed appearance. Proof of service. He must have filed an appearance of some sort.
You might have, because I think, I'm thinking now, I looked at, I think yesterday we did get discovery. My assistant's much faster than me.
Oh, gosh.
That's why I have her.
Okay, so we'll get you. June 15 at 10.
Was it, Your Honor?
June 15th at 10.
That works perfectly. Thank you.
Okay. Mr. Atkins, did you have any questions for the court today?
No, ma'am.
A bond was set at 5,000 personal recognizance with a no contact order protecting the alleged victim by an entry. That will continue. Any additional matters for the record, counsel?
Nothing on behalf of the people, thank you, Your Honor.
Nothing else, Your Honor. Thank you.
All set. Thank you.
Thank you.
Madam President, here's an knowledge for Stevenson. You want me to give it to Abby here?
We're going to Virginia. Just two.
Awesome. Have a good trip.
Yeah. It's good.
Nice.
You see some food.
Mhm.
That's nice.
That's good.
See you soon.
Have a good one. Have here? Is this?
I believe it's Mr. Calvin.
Mr. Adams?
not going to be able to make it in. There's a water break at his house. There's currently water going everywhere. He's got to call a plumber to get a plumber in.
Oh, okay, so it's like, yeah, so you have how many witnesses today?
I would have one for today, Judge. And I don't know how many Mr. I think Mr. Rabbit maybe was going to call one as well.
Sounds good. Any other preliminary matters before we begin?
I would just ask for sequestration of the witnesses since Mr. Rabbit let me know that he may call a witness.
Sequestration is granted. How many witnesses do you have here, Mr. Abbott?
Just one, me.
One potential witness. Okay, this is sequestration order. So if your potential witness is not sit in the courtroom during the proceeding. So you're not to discuss any portions of your potential testimony either with any other witnesses. Okay. Call your first witness.
Thank you, Your Honor. At this time, people call Haley Dimstra.
Raise your right hand. Face me. Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. Thank you. You can have a seat. There's a microphone that's in front of you, ma'am, and right behind you is my court reporter. So she has to take down everything that's being stated here today. So I need your responses to be verbal. They need to be loud and clear. I'm gonna actually speak louder than your normal voice because I'm congested, so I really can't hear. And then if there's an objection by either of those attorneys, you'll stop speaking. I'll give a ruling on that objection and I'll give you an answer as to whether or not you can give that response or not, okay? Also, we can't do head nods or head shakes or mhm and ahas because we can't write that into the record. So we need you to answer yes or no questions with yes or no, okay? You say your first and last name and spell both of them.
Haley Churchdraw, Hailey, and Churchdraw, TDRPSTRA.
Oh, good to see.
Thank you, Your Honor. Morning, Haley.
you.
On April 20th of 2023, where were you staying?
I was in a mixture of hotel rooms. It was like for 4 days.
Were
in a row.
you at a Quality Inn?
Yes,
Is that, do you know the address of that?
I do not.
Is it in Lansing?
Yeah.
Is it in Egan County?
Yes.
And who were you at the hotel with on that day?
My ex, Zachary, and his girlfriend, Mackenzie.
Can you give last name Zachary
Cowden,
and Mackenzie?
Mountain.
And how do you know, Zachary Cowden?
I was his girlfriend for about 2 years prior.
And is that person in this courtroom today?
Yes.
Can you please point to them and describe something they're wearing?
The husband's out.
Let the record reflect the witness identified the defendant.
Any objection? Identification is noted.
Okay, so, and you were there with Zachary and you said Mackenzie?
Yeah.
What happened that night?
We got in the hotel room and I was on the phone with a friend of mine talking to them about who all was there. And Zachary had stated that it didn't matter who was in the room. And I repeated that and he had gotten a little upset with me for doing so.
Do you know why he got upset with you?
I do not.
How do you know he was upset with you?
He started yelling at me by saying it don't fucking matter when they asked me who I was in the room with who I was on the phone with.
Do you remember about what time this was?
I do not. It all happened quite quickly.
And so after he said that, what happened next?
He came towards me and kind of like hovered over me for a second and then walked behind me after yelling at me.
Where were you at when? Where were you sitting? Was this a double was this a
Yes.
double bed room or a single bedroom?
That was bad.
And so where were you sitting at the time?
Closest to the door, on the bed closest to the door.
And when he started yelling at you, where was he?
On the bed behind me.
You said he started yelling at you and then he got up and began to walk somewhere?
He walked towards me and then I told him to stop. He did for a second and then walked behind me and I felt something. I don't know if it was his hand or what, but I felt force on my head.
You felt somebody strike you in the head?
Objection, Your Honor. Leading the witness.
Objection sustained.
I was asking for clarification. She said that she felt.
You can ask her to clarify.
Can you clarify what you meant by force on your head?
I felt like something struck me upon my head.
And what side of your head was that?
The left side.
And this came from, where did this strike come from?
From behind me.
And what happened after you were struck?
I just started to cry and Mackenzie yelled. I remember hearing her yell. I don't remember exactly what she yelled.
Who yelled?
Mackenzie.
Where was Mackenzie? Excuse me, my throat's kind of dry too. Where was Mackenzie when you got struck?
She was on the opposite side of the room.
And so do you know who struck you?
Zachary.
And so after that, Mackenzie started, you said Mackenzie had started to say something?
Yeah, she yelled for him to stop, I believe is what she said. I don't remember exactly what word for word because it did happen fast. And I just started crying, asking why.
Did he give you any explanation?
No.
Did he, sorry, did he move to any other position after?
No. Like he was still behind me.
And he didn't, sorry, geez, excuse me. He didn't say anything after, did he say anything after he struck you? What did you do next?
I went to the ground, started crying some more, and then that's when she came up to me and like kind of reassured me that things were okay.
When you were on the ground, where were you located?
I was like sitting at the edge of the bed closest to the door.
So you're closer to the door, you weren't between the beds, you were on the side close to the door, okay. And so he was trying to reassure you, what do you mean by that?
That it's okay, and that he was sorry.
And did you do anything after that?
He kind of held me for a second, not in a mean manner or anything like that, but he realized that this was wrong.
How did he hold you? Was it
Like he kind of knelt down on the ground, and held me with a hug.
did you notice anything in his hands at any point?
I wasn't really trying to look for anything. I was following my head out.
And excuse me, how hard did he smack you or strike you?
not hard enough to leave a bruise, but like there's a red mark, I guess. It's gonna happen when you get slapped.
Was there a knot or anything?
It's like one.
At any time did he tell you to try me?
Not that I can remember.
You said he apologized for it. And what happened after that?
I got in the bathtub. I got in the shower. By the time I came out, him and Mackenzie were sleeping.
I'm sorry, when she came out, what happened?
Mackenzie and him were sleeping.
What did you do next?
I laid down and I tried not to fall asleep, but I did. And then that's when I got woken up to them moving the door.
Did you text anybody about this incident?
Yes, my boyfriend at the time.
No further questions. Time and everything.
Cross-examination.
So when this happened, there was how many people in the room?
Great.
And you said that Zachary was behind you
Yeah,
when you felt something strike you?
yeah.
You didn't see him strike you?
No, but I've been with him prior to 2 years. I know how he was.
And,
When this incident occurred, you all just got to the hotel room?
It was probably about an hour and a half of being there.
I think it was about an hour and a half. And it was just the three of you in a hotel room?
Yes.
And you said you were calling someone?
I was on the phone with one of my friends that works on cars, explaining like what had happened on my car, like the noises it was making, to see if they would come look at it.
Okay,
And that's when they asked me who I was at the hotel room.
gotcha, okay. Sorry, do you know what you were struck with in the head? Was it do you know if it was a hand or an object?
I couldn't tell.
Couldn't tell. Either way.
I think you just cleared up my question, Judge. Thank you.
Any cross-examination based on my question?
thank you.
Can this witness be excused?
Yes, Your Honor.
Thank you, ma'am. You may be excused.
If you want to wait in that room, we'll talk to you.
Not from the people at this time, Your Honor. I would ask for, at this time, I would ask for a continuance for the officer involved that responded to come in to testify, Your Honor.
Mr. Abbott, my understanding is that you may have witnesses, but I'll let you want to call them right now.
I don't. Thank you.
So we'll continue to another date.
Added May 19. Yeah, May 25th at 10.
May 25th at 10. May 25th at 10. Any additional matters today?
No, nothing from the people, Your Honor. Thank you.
Your Honor, regarding the issue of bond, is there a bond report written?
Let's go on this side of my file. Did you make a request for a bond report?
No, Your Honor.
bond, when fire bond was set at the time of arraignment, $20,000 cash surety with GPS tether.
Yes, Your Honor. So far, we've heard the eyewitness, and we've heard about one misdemeanor. We consider reducing bond to something that he can afford, personal cognizance.
Your Honor, I think bond is quite appropriate in this matter. I do plan to add 2 witness intimidation charges, one for each of the witnesses, Your Honor. There have been multiple calls to at least the one eyewitness that defense plans to call, and basically instructing her to say different things. There's an allegation that $1,000 were offered to not come to court to testify via these various jail calls, and there has been a supplemental police report already wrote up on all of these calls, Your Honor.
No jail calls. I'm sure you advise your client about jail calls.
Yes.
My motion is denied. The additional matters. were
Thank you.
Nothing on behalf of the people. Thank you, Your Honor.
Um, On the record in the matter of the people of the state of Michigan versus Percy Harrison, file number 22-01722, FY, council appearance.
Ryan Ring on behalf of the people.
Good morning, Your Honor. Jacob Sarson, fourth assistant public defender here on behalf of Mr. Harrison. I'm appearing in person. Mr. Harrison is scheduled to appear by polycom this morning.
Right, Mr. Harrison did not appear via Polycom. We did make an attempt to call Ingham County Jail, but it looks like they're having some technical issues with their phones. We were not able to make contact. In the past, Mr. Harrison has refused to participate in any of his court proceedings. Would you be waiving his appearance for today's purpose?
Yes, Your Honor. I did receive an update from Lieutenant Earl and the jail administration. We're still waiting on bed space for him down at the treatment center down in Kalamazoo. Your Honor determined he was incompetent to stand trial. I had an opportunity to meet with him this week with our social worker, Your Honor. He still absolutely needs that treatment, so I'm not going to seek any amendment to that order or anything along those lines or ask for any sort of reevaluation at this time. I think the treatment would be very helpful for him. So unfortunately, at this point, we're still waiting on a bed space. Thank you.
It was back in October. I think that the update we got was it was 8 to 10 months
Correct, Your Honor.
was the time that they were seeing. So we're going to set this out another 60 days and we'll do an internal review.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of the bench. Thank you.
It was July 13th. It's an internal review, so you and Nick will figure out if it needs to be reset. Okay. And if so, just reset it. No one needs to see it.
Narrow walkway there.
Okay, on the record in the matter of the people of the state of Michigan versus Matthew Christie, file number 23-00612. Council appears.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Christie. He is present to my right.
If date set for a sentencing, I do have a pre-sentence report. A recommendation, Mr. Austin, did you get a copy of that?
Yes, we did, and I showed that.
The updates, corrections, and deletions.
Just one update, Your Honor. Mr. Christie tells me that he has been making attempts to get his assessments done through CMH. They may be playing a bit of phone tag, but he does tell me that he is making that effort.
Why didn't you complete your assessment as ordered by the court? Why did you not complete the assessment that I ordered you to complete before your sentencing?
I've been trying I've tried Crystal Lake 3 different times, and I tried CMH twice. They told me to call back within 20 minutes, and I called back in 5, and they did not answer the number. And I was.
Okay. Did you make contact with the probation department because they could have given you an assessment? And then they would have attached an assessment fee onto your sentencing.
We did, we called her back when she called on 26.
That's not what this says. Says she never heard back from you. Your fiance was your fiance a defendant in this matter?
No, my phone was broken.
Okay, well, so you can't borrow the phone from your fiance and call on your own. Is your fiance gonna be on probation or serve your jail time for you? Okay, so you want me to put you on a term of probation, sir?
Yes.
And you want me to give you 7411 status? But you don't want to follow my order to get there.
Try.
No, it's not a try, you just do it. This is the, well, that wasn't a heavy lift. You either go to CMH or another, they gave you a whole list of agencies where you can get a substance abuse assessment. But if you couldn't do that, you can just let the probation department do it. And there's a $90 assessment fee. It's really simple. It's not difficult. Not gonna grant you opportunity for probation, so you can show me that you don't follow court orders if you're not following court orders before we get there. You understand that? I'm gonna reset this. You go get your assessment. Okay? July 6th. July 6th at 8:30. Do you have any questions today? Any additional matters for the record, counsel?
I have nothing further about Mr. Christie, Your Honor.
Okay, we'll get you a copy of your notice to appear. I don't know what else. Miss that attorney went. Is Alfonso Gibbs here? Mr. Gibbs, did you get your fingerprints done? No. Okay. Well, you can get your fingerprints done and then we'll be ready to move forward with your case. I can't hear you, sir.
I never looked at I had.
We need your fingerprints, so we're gonna send you downstairs to get fingerprinted, okay? They know the people that do the fingerprints. You're coming right back upstairs, okay? Does he have an order? Does he need an order to take with him? Can someone let him know? Okay. Is everyone else in custody? That's his client in custody. Mr. Karani's in custody. Ms. Armistead is here, but her attorney is not. Mr. Milks is here for Richardson and Easley. Who has someone that's present in the courtroom?
We can do easily. Mr. Davis is here on that P53, Your Honor, with Mr. Abbott.
On the record in the matter of the people of the state of Michigan versus Anthony Davis, file number 21-03352. Counsel here.
Brian Ring on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Davis. He's present, standing to my right.
Supposed to be having a hearing on the P53. Is that what we're doing?
I believe so, Your Honor, but I wanted a quick second to talk to you about that. I know that Mr. Davis has been referred to a competency eval, so I don't know if we should be holding a P53 hearing while that competency eval is outstanding.
I agree. I believe that it's just the day before he, or me, at least a week before this, he waived another file up. I don't think that should have been waived over either, because he came to court the next day and expressed concern about his mental health. So I'll leave that to his attorney to get that taken care of. We'll reset this. Review date on this comp was May 25th. You're not about to have anything for me. Forensics, by the way.
They haven't even scheduled the
So
interview yet.
forensics needs to be hiring because they're inundated. If I can move both of these out. June, end of June. June 29th at 8:30. We'll reset the review to June 29th at 8:30.
Thank you.
No problem.
Thank you, Judge.
No problem. Any additional matters for the record?
Nothing for the people. Thank you.
Ms. Armistead?
Hello,
All right, I don't know where your attorney went.
you said what, ma'am?
I don't know, your attorney is not here. I
Oh,
don't
she-
know where she went.
I don't know. She
You
just
have her
said she's
number?
on. I do. You want me to text her?
You should probably get in contact with her and ask her where she is, because you're in court and we have a few files for you today.
Okay, I'm calling right now.
Duke here?
Yeah.
Okay. Are we running?
I don't have notices.
On the record in the matter, the people of the state of Michigan versus Ariana Lachey Duke. Is Ms. Duke gonna come and join us?
If she has a small child, I can bring her in.
She needs to be.
Let's do.
I just talked to her. She said she's zooming in right now.
Thank you. File number 23-01294, council appearance.
Brian Ring, excuse me, Brian Ring on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Ms. Duke, who is present and standing at council table.
Thank you. Ms. Duke, today was the date set for a preliminary examination. My understanding is that the people do not have the necessary witnesses to proceed.
That's correct, Your Honor.
Okay, so this case will be dismissed without prejudice. That means if the people do have the right to reissue the charge if the necessary witness appears and is ready to proceed with the case, okay? I'll get you a copy of your dismissal today. Do you have any questions at this time? Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing. Thank you.
Thank you.
Just my standard procedure. Send out.
On the record in the matter, the people of the state of Michigan versus Leasia Armstead. File number 21-02870. And then I have file number 23-01169, council appearance.
Brian Ring on behalf of the people.
Good morning, Your Honor. Melanie Elby, attorney for the defendant. She's appearing by Zoom.
Thank you. Ms. Armstead, today was the date and the time set for preliminary examination. However, we do have a PA 53 violation that was set for an arraignment for today, which means you are to appear in person. I can't hear you.
I thought on the court paper I had a mail said via Zoom too.
Yep, you were supposed well, first of all, a preliminary examination is always in person, so you would not have gotten a notice that told you to appear for an exam via Zoom. I noticed I have a note here that there was a request to waive to circuit court. Maybe your attorney told you you could do that via Zoom, but since then, you've picked up a violation, alleged violation of your bond, a PA 53 violation. And so you have to be arraigned on that. That was set for an arraignment today. You have to appear in person. We also have a bench warrant that issued for you on the 8th on a false information furnishing false information, and it looks like you failed to appear for that court date, so there was an expired meter that you got a default judgment on, and you owe $96 on that. Does she have a misdemeanor too?
Yes.
Then you
That's
have
all.
another
You said it
misdemeanor, which has the, you have a misdemeanor pending as well, so that the PA 53 would apply to that as well. So you have bond violations pending, and then you have this bench work. So I need you to appear in person today.
Okay.
All right, what time can you and your attorney be here?
I just gotta call, make sure somebody can pick my daughter up from school, and then I'm gonna come. And then I'm gonna call my attorney.
Okay, thank you.
Thank you.
Rock the record. Okay, Mr. Karatni is in custody. Mr. Hughes is in the jail getting his fingerprints done. Mr. Hess is Roberts. We're running Roberts.
As far as I know, yes.
You can bring him up. Mr. Milks left. We have Richard Perry and Easley. Correct.
Correct. I don't believe Mr. Easley, excuse me, geez. I don't believe Mr. Easley's here, and I know that Mr. Richard, is it Richardson?
Is it custody?
Is in custody, yeah.
You don't think Mr. Easley's here?
I do not think so, but I don't want to say that for sure.
Robert? Louis Easley.
Oh. Oh, I don't know.
No, it's a defendant.
Oh,
You can
I
probably-
guess I could still theoretically open.
We can bring up Roberts.
Roberts.
we planning to run Mr. Gibbs at all?
No, Judge, I don't have any answers.
Oh, was his attorney here?
Dale was just in here. I don't know where, he asked me if this was gonna be long, I told him we had one. I had one witness, so. I'm afraid to stay so she can sign it. Where the other one? Doesn't matter. Somebody to sign me. Might be on the second floor. Might be on the second floor soon.
So what?
Might be on the second floor with the circuit court soon. Garcia's got a law clerk spot open on that floor.
We're on the record in the matter of the people of the state of Michigan versus Alfonso Gibbs, file number 22-03549. Counsel appearance.
Brian Ring on behalf of the people.
Thank you, Honor. Dale Coltrader on behalf of Mr. Gibbs, who's standing immediately to my right.
Okay, today was the date set for a preliminary examination. My understanding is that the people do not have the necessary witnesses.
That's correct, Your Honor.
So this case will be dismissed without prejudice. So that means the case is dismissed today, but the people do have the right to reissue the charge. Whatever. Is the witness an officer?
It is, Your Honor.
You subpoenaed your officer?
I did, Your Honor.
Your officer failed to appear?
You did.
Okay. All right.
Your Honor.
Yes. Oh, you can sign it. That's what you were saying. Yeah. I'm sorry.
No, you're good. You should be good now.
I'm sorry. I thought about it.
Yeah, you should.
Nice try.
Oh, for real?
I didn't sign it.
I have one more after this.
I didn't sign it.
He's gonna be there. Have to then. so. Yeah, you're good.
On the record in the matter of the state of Michigan versus Terrell Roberts, file number is 23-00842 FY. Counsel appearance.
Brian Ring on behalf of the people.
Thank you, Your Honor. Good morning. Edward Hess appearing on behalf of Mr. Roberts. Mr. Roberts is standing to my right. The council table having been transported here from the Clinton County Jail.
Very good. Today's the date and the time that was set for preliminary examination. Are we ready to proceed?
People are ready to proceed the same, Your Honor.
Defense is ready, Your Honor.
Any preliminary matters?
None for the people, Your Honor.
No preliminary matters, Your Honor. Thank you.
Call your first witness.
The people will call Trooper Luke Schaefer.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
Thank you. You can have a seat, Trooper. State your first and last name and spell both of them.
Trooper Luke Schaefer, LUKESHAFER.
Thank you, Your Honor. Trooper Schaefer, where do you work?
With the Michigan State Police
How long have you been working there?
since June of 2019.
And what capacity are you assigned?
Currently as a road trooper.
Were you working in that capacity on the 6th of September, 2022?
I was.
And were you in uniform at that time?
I was.
You were on a patrol vehicle? Or-
Yes, holding my.
And did you initiate a traffic stop?
I did.
Why did you initiate a traffic stop?
For defective equipment, license, and EIP, no.
Did you remember the vehicle? Do you remember the make and model of the vehicle that you made that traffic stop on?
I would have to look at my report to refresh it with the silver, I believe, guide.
And once you made that traffic stop, did the person in there identify themselves?
Yes.
How did they identify themselves?
There's a photo on his phone. He couldn't provide me a hard copy of his driver's license at the time.
And so he provided you with a license, a picture of his license on his phone?
Yes.
What was, do you remember the name on that?
Terrell Roberts.
Was that the person driving the vehicle?
Yes.
Was there anybody else in the vehicle that day?
No.
Is the person that was driving that vehicle in the photo today?
Yes.
Could you please point to them and describe something that way?
Yep, just a yellow. So
Let the record reflect the witness identify the defendant.
Any objection to identification?
No objection for purposes of prelim.
Identification is noted.
And what did you do after making contact with him?
So I made a passenger side approach from the vehicle. During contact, I introduced myself, requested driver's license, registration, proof of insurance on the vehicle, which he advised he didn't have at that time. During that contact, I observed a hindsight vodka bottle on the passenger side floorboard of a clear glass bottle with a lime green lid on it.
May I approach you on showing what's been marked as people's proposed exhibit 2? Take a minute, look at that. Do you recognize that?
Yes.
Is that what you saw? Is that picture an accurate description of what you saw in the car, in the vehicle on that day?
Yes, sir.
Does it appear to have been altered in any way?
No, sir.
People move for admission of people's proposed 2.
Any objections to people's exhibit 2?
Objection for purposes of this hearing only. Thank you.
People's 2 is admitted.
So in this photo, can you kind of describe what you're seeing in this photo?
Yep, so this is the passenger side front floorboard. There's a paper towel, 2 bags, glass bottle that's face down, and then a couple of this one in the box.
And you said this was a bottle of vodka?
Yes, based off my training experience, so this is a common bottle of vodka or some sort of toxin.
Did you ask him about that?
No.
So what did you do after you saw that?
So during that still initial contact, there's also a small plastic baggie was clear near the leadership of the vehicle. Once again, based off my training experience, those are commonly used for transporting narcotics, stuff like that.
May I approach your honor?
You may.
Showing what's been marked as people's proposed 4. Take a look at that. Does that picture accurately describe the plastic bag and the location of the plastic bag that you were just talking about?
Yes, sir.
Does it appear to have been altered in any way?
No.
People would move for admission of people's proposed at 4.
The objections.
No objection.
People's 4 is admitted.
Okay, so you saw the bottle of vodka, you saw this plastic bag. What was your next steps?
So based off him not having his driver's license and then also me building probable cause at this point, I had him exit the vehicle, so I could talk to him at the front of my patrol vehicle, the rear of his vehicle, so I could properly identify him. And during that time when he was showing me his phone with his information on it, he made a statement like why he got pulled over, asked if it was for him not having insurance on the vehicle, which I didn't advise him it was. After I had his information written down, I informed him of the bottle and then kind of briefly explained the MCL for open intoxicants in the state of Michigan. Just advising him I had probably caused it time to search the vehicle. At that time he instructed me, he wanted to call his lawyer, and then he told me he wasn't gonna unlock the vehicle. At that point, he started to walk away from me, just due to the behavior change and me already having probable cause to search the vehicle. I detained him in handcuffs.
When you detained him, did you detain him in your vehicle or?
Yeah, so I put him in handcuffs, checked the prevention, double locked the handcuffs, put him in my front seat, seatbelted him in with our seatbelt lock and all that. And then I went about my probable cause search.
And did you search that vehicle?
I did.
What did you find in that vehicle?
So the open alcohol bottle was in there, tie-off baggie by the beer shifter. There's also a lunchbox on the rear passenger seat or rear passenger compartment area. In that was, I believe, 2 baggies of like a white crystal substance. There's also a brown baggie, and then I believe 3 pink pills, weed, scale, individual baggie.
Madam Pro Chair,
Yeah.
I'm showing what's been marked people's proposed 3 and 5. 3 and 5. Is that the lunchbox that you saw?
Yes.
And is that the contents of the lunchbox and people's proposed, was that 5? Is that the contents inside just laid out on something?
3 is, and then 5 is it laid out on my hood, but then there's also the tie-off baggie by the beer shifter that was put in that as well.
And do those pictures appear to be altered in any way?
No, sir.
Do they fairly and accurately depict what you saw?
Yes, sir.
People move for admission of 3 and 5.
Any objections to people's 3 and 5?
Objection for this hearing only. Thank you.
3 and 5 are admitted.
Did you have a chance to ask the defendant about those items?
I did. So after Miranda was read, I completed an interview while he was seated in the front seat of the car.
And did he agree to speak with you after you read him Miranda?
He did.
And what did he tell you about?
He said he had approximately an ounce of methamphetamine in there. He sells it to make a couple bucks. He said he was going to try to sell it for, I believe, approximately $400. He would keep 100 of that. He also advised that there was heroin mixed into the stuff that I located.
Was the vehicle going to be towed?
Yes, it was, with no insurance.
And the suspected drugs that you found, were they true narc?
Yes, sir.
Were you the one that did the true narc?
No, I had trooper marks and do it. I was standing with them.
So did you see the reports and the outcomes of those true narc?
Yes, sir.
Do you remember what those came back as?
So the white baggies we did 2 tests on, both came back as methamphetamine. The other 2 were inconclusive, which were sent to the lab. One came back as fentanyl, one came back as another agent.
And I'm gonna circle all the way back to the beginning because I see that I missed some. Where was this traffic stop at?
So once I turned my lights on, it was Oakland between March and Cedar.
Is that in the city of Lansing, in County, Michigan?
Yes, it is.
Thank you. No further questions this time. Thank you, Your Honor.
Processing.
Yes, thank you. I'd like to retrieve the exhibits, please, Your Honor. Good morning, Trooper. I'd like to refer you to, morning, sorry. I'd like to refer you to what's been labeled as Exhibit 2. That's what you identified as a vodka bottle.
Yes.
From your vantage point, were you able to see if that bottle was empty?
Not from where I was standing. I couldn't 100% say like it was completely empty, but it was definitely, it wasn't.
Were you able to see if the bottle had a cap on it?
Yes.
Did the bottle have a cap on it?
Yeah, it was like a lime green, green metal cap.
From what you observed during your passenger side contact, it appeared that the cap was screwed onto the bottle. Is that correct?
Yes, it was on the bottle.
Now, this, what you referred to as a, what was your description for the baggie? What was that name?
So like what we call it is a clear knotted tie-off baggie or plastic baggie, something like that. Like you can see in the photo, it's ripped. So what happens, based off my training experience, illegal narcotics will be put in these corner tie baggies. They'll be knotted, and when they go to use them, they'll just rip the knot off, and that's what opens it up. That's exactly what's in the photo on that plastic baggie, is that knot that's ripped off.
What do you mean by corner tie?
So it's like a clear plastic baggie of some sort, either Ziploc baggie or some sort of plastic wrap that has been, so you can throw narcotics in it, then you tie it. That's what we call like the knotted baggies or the corner ties. So, yeah.
From your observation during your passenger side approach, you didn't see any kind of substance inside this baggie, is that correct?
I couldn't tell at the time.
You couldn't tell if there was a substance in the bag?
No.
Now, you had Mr. Roberts detained prior to searching the vehicle, is that correct?
Yes, sir.
What you described as a lunchbox was found in the backseat of the vehicle by you, is that correct?
Yes, sir.
Was it zipped up or closed in some way?
Yeah, so it wasn't open.
Okay. And did you unzip it?
Yes, sir.
Did you search any other compartments in the vehicle?
Yes, sir. I did a complete search of the vehicle.
Okay. I have no further questions, Your Honor. Thank you. I'll return the witnesses. Well, I'll just give the exhibits back to the prosecution.
Thank you. Publish those to the court.
Yeah.
Direct.
Thank you, Your Honor, briefly. Before towing, do you commonly search a vehicle before towing?
Yeah, so if we're just calling it based off of non-arrest or like no insurance, suspended driver, we do an inventory search of vehicles, documenting valuables, stuff like that.
So the purpose, what is the purpose of that inventory search?
Just to document valuables on the tow sheet.
Okay, and did you send the other two unknown substances off to the lab?
I did.
Okay, thank you. No further questions. Your Honor.
What's happening?
I'd like to recross
Why would you want to recross?
on the issue of whether this was an inventory search or not.
He didn't address that on the direct exam, is that what you're saying?
Yes.
See.
Right, Officer, you never referred to this as an inventory search on your direct testimony, correct?
No, this was a probable cause search just based off of observations I had prior to me having to step out of the vehicle.
So it's your position this was a probable cause search?
Yes, it was a probable cause search, but if I didn't have the probable cause, the vehicle would have been towed and inventory due to the no insurance.
But you did not, in fact, perform an inventory search of the vehicle, correct?
I mean, that's part of my whole search as well, because I towed it, I still have to do an inventory no matter what. So even if I have probable cause, verbal consent, doesn't matter what it is on the vehicle, if the vehicle's being towed, I still have to do a what we call UD 91, that's an inventory tow sheet. I still have to complete that no matter what.
Did you complete that in this case?
Yes, sir.
You know if that's been disclosed to the prosecution?
Assume it was sent off with the warrant packet.
Okay.
We got that file, so.
Okay. So it's your testimony that you completed an inventory form?
Yes, it's documented in my report at the bottom under external documents. It should be UD 91.
It's called a UD 91?
Yes, sir. And then also because it was entered as lien or entered into lien as impounded, there's a lien reference number as well. That was added to the tow sheet as well.
Right, may I approach the witness, Your Honor?
You may.
All right, witness, this is just to refresh your memory.
Yes, sir.
Actually,
Wait, what are we refreshing his memory about?
I'm sorry, Your Honor, I misspoke.
Oh,
Witness, do you remember where in your report you listed the UD 91 and the lien number?
It would be towards the end of the report.
Okay.
Under the tow heading would probably be where the vehicle is towed to, by who. Then I call my station for dispatch, which is an MSP dispatch, giving them information of the vehicle. They enter the vehicle and the lien is impounded. They give me a lien reference number, and that's been added to the report.
Okay, and to the best of your recollection, that's what you put into your report?
Yes, sir. It would be, like I said, the last page, the technical last page.
Okay. No further questions, Your Honor. Thank you.
I just want to clarify, you said that there were, was it 3 bags or 4 bags recovered that were tested?
So for the True Narc, there was 4 total tested. 2 came back as methamphetamine. 1 came back as inclusive, or 2 came back as inclusive as well, inconclusive. And those are the 2 that were sent to the lab for further testing.
Okay, so the 2 came back to Narc as meth, and then the other 2 went off because they were inconclusive. When did those come back to the?
1 came back as fentanyl, and then the other one, it starts with an E. It's in my supplement report. I just don't recall off the top of my head.
Maybe the prosecutor can refresh your recollection.
And I do have that lab report, Your Honor. I was waiting until he was done. I was going to admit that lab report.
I asked him a question, he can't remember.
May I approach, Your Honor? I'm showing you the lab report to refresh your recollection of what the
Yes.
second substance was called.
That is it.
I don't know how to pronounce it either, Judge.
Can you spell it?
Yeah, it's EUTYLON.
Okay. Does anybody know what that is? Is it a controlled substance?
It is, Your Honor.
Okay. Do you know if that's a controlled substance, or this lab report is gonna indicate that?
Are you asking me?
I'm asking the prosecutor, is your lab report that you're gonna submit indicate whether or not that's a controlled substance?
It does say what it is also commonly known as.
Okay.
It has the schedule
Sounds
on
good.
the lab report.
Perfect. Thank you. Any redirect or cross-examine based on my question?
None from prosecution. Thank you.
No further questions.
Thank you. Trooper Schaefer, you may be excused.
Thank you, Your Honor.
Call your next witness.
Yeah, at this time, the people have no further witnesses and we move to admit people's Clause 1 under MCL 76611B, the self-authenticating document of the lab report for preliminary purposes.
Thank you. Any objection?
Okay. Real moment.
Okay. Is the defense calling any witnesses?
No, Your Honor.
You can proceed to argument.
Thank you, Your Honor. Your Honor, we heard testimony for Trooper Schaefer, who pulled his vehicle over with it from expired tags. The defendant was he noticed this pint of vodka on the floorboard. He couldn't tell whether it was opened or not at that time. He asked the defendant to step out. He noticed this baggie in the center console. He began to detain the individual for further questioning. He asked him if he could search the vehicle or if he had anything on him. He declined at that time. He had probable cause to search that vehicle based on the container and the baggie. Furthermore, it was going to be inventory search anyways because the vehicle, as the trooper testified to, it was going to be towed. And during that search, he found 3 different types of narcotics. That being methamphetamine, true narc positive, that being fentanyl. The lab report came back fentanyl. And then the UTYLONE, which came back in the lab report, which is a Schedule 1 drug from the lab report as well. The defendant was Mirandized, and the defendant agreed to answer his questions, and the defendant told the officer that he had bought that and that he was going to sell it. He had planned to sell it, Your Honor. So it asked that all 3 counts be bound over to the circuit court. However, I would be not ask. Actually, sorry about that. Give me 1 second. I would not be asking all the counts to be bound over. I would be dismissing count 3. I would be dismissing count 3 and adding a count 4 because it was charged incorrectly. It should be, the count 4 should be MCL. Sorry, had it ready and then I lost it.
For this,
Is that it?
it's the email I'm sent. I don't have the pack code, but I've got the MCL. So that's what-
Yeah, under MCL 333.74012B-A. Controlled substance delivery manufacturing schedule 1, 2, and 3, except marijuana, methamphetamine, ecstasy, and cocaine, and that is a 7-year and/or 10,000
333.74012B.
-A.
Any other controlled substance classified in Schedule 1, 2, or 3, except marijuana, that one?
That's correct, Judge.
Okay. Felony punishable by imprisonment of not more than 7 years or fine of not more than 10,000 or both. Okay. Defense.
Your Honor, I will, before I get to the meat of my argument, I will address the prosecution's proposal to add an amended count 4 instead of count 3. If the court indeed does bind over on that count, the way to correctly charge it would be, as Mr. Ring has mentioned, the Utah loan is considered by the government, perhaps by scientists, to be a synthetic cathinone. So it falls under that category of Schedule 1 of the Michigan Public Health Code, controlled substances, as well as under the federal government. Clearly, I don't have to argue that today. I do have the documentation with me, basically showing that it's not a narcotic and it's not cocaine, but I was able to reach out to Mr. Ring yesterday, and he was able to talk to somebody in his office who does a lot of drug prosecutions, and we're on the same page as far as how that should be charged if indeed the court does bind over. Now, Your Honor, as far as the case in chief goes, the people that presented evidence from Trooper Schaefer today, as well as the laboratory report gets submitted under the evidentiary rules set out by the statute. There was testimony that this vehicle came back as having no insurance in the Secretary of State system. The driver didn't have a license on his person. The Trooper Schaefer observed a vodka bottle. He could tell it wasn't full. He didn't know if it was empty or not. He did observe a cap screwed onto it. He also observed an empty baggie on the gear shifter. He could not tell if there were any substances in the baggie. He testified it was in his training experience that this sort of empty baggie, which he referred to as a corner tie baggie, is used for the transportation and sale of illicit narcotics. Your Honor, the prosecution's case comes down to whether or not the search of this vehicle was valid. Clearly, there was no consent from my client to search the vehicle. My client was safely out of the vehicle and secured when the trooper initiated the search. Now, if this was really a probable cause search, Your Honor, I would argue that there was insufficient probable cause for the trooper to search the vehicle. An empty vodka bottle spotted on the floor is just that, a quick scan of the vehicle to see if there are other open containers or not. An empty baggie is not sufficient evidence to search a vehicle, especially to open containers such as the lunchbox that was found in the back seat. People have empty baggies for any number of reasons. Anybody who's ever commuted or eaten lunch in their car might have an empty sandwich baggie or anything else in there. Just because an empty plastic container is in plain view doesn't mean that the trooper gets to open all the different compartments and do a complete search of the vehicle. Now, we later learned through redirect that the trooper also believed this to be an inventory search. There was an inventory search form completed. Nevertheless, Your Honor, the ostensible purpose of the inventory search is to find valuables. There still would have been no reason for the trooper to open this container in which he found the alleged illegal drugs. As far as the drugs themselves go, Your Honor, the statute does require that for a field test result to be admissible, it must be properly performed. First of all, there was no field test result admitted besides the trooper testifying that the substance came back with the true narc as methamphetamine. However, the true narc printout was not admitted. The trooper did not perform it himself. There was no testimony laid as to whether or not that was properly performed. So I would ask the court find there's not probable cause that the substance that came back as methamphetamine was in fact methamphetamine. Second, Your Honor, I do understand that the laboratory report has been admitted pursuant to the statute. And my argument rests more on asking the court to suppress the search rather than contesting the results of the lab report. I've already commented that under federal and Michigan law, utylone is a Schedule I controlled substance, and the prosecutor moved properly that count 3 be dismissed, and if the court finds over that it should be for the 7-year period. So, Your Honor, I would ask that all the counts be dismissed. However, if the court does find over as to amended count 4, that the case be bound over for the utylone rather than for a narcotic, which there's no evidence at all that utylone is a narcotic. Thank you, Your Honor.
The argument,
very briefly,
as it relates to the argument about whether or not there was a proper administration of true narc.
Your Honor, the officer watched the true narc. He saw the results. He saw the scan. He testified to that. He testified to what he saw. He was allowed to testify to what he saw. He saw that come back as true narc as positive for meth. He said that he watched the entire test of the controlled substance. As to the search, Your Honor, it was going to be an inventory search regardless of whether there was probable cause or not. That vehicle was going to be towed. There was going to be an inventory search done anyways, and those drugs would have been found during that inventory search, which did occur.
Your officer testified that he saw another officer do the true narc, but that was the extent of what he testified to. He didn't testify whether or not it was properly working at the time. He didn't give any of that information. Why wasn't the officer who performed the true narc subpoenaed?
He wasn't available today, or he wasn't here today, Your Honor. I did speak with my trooper ahead of time, and he watched the true narc be done. He watched the true narc scan be done. So I proceeded today with him as his testimony because I believe there's probable cause.
Okay.
With the low burden, I believe there's probable cause.
Did he testify as to whether or not that true narc was operating properly at the time?
He did not, Your Honor. I did not ask him that.
Well, can he? You can put it back under oath.
Absolutely, Your Honor.
Officer Schaefer. You're still under oath to tell the truth under penalty of perjury.
Yes, sir.
Trooper Schaefer, when you watched the other officer do that true narc test, did you observe him perform any tests before that?
Yeah, so he did the self check before and after the test, which is required under the Then during the test, like I said, he tested methamphetamine, that came back as methamphetamine. And then the other two were tested.
And did you see readouts of that true mark?
I did.
May I approach, Your Honor?
Yeah.
May I get these marked as 6 and 7? I believe it's 6 and 7. I'm showing what's been marked as 6 and 7. Take a second. Just look at those. What are those?
So those are the True Narc scan reports.
And do those appear to be accurate?
Yes,
Do
sir.
they accurately depict what the true mark scans look like and look like on that day?
Yes, sir.
People move for admittance of 6 and 7.
The objections to 6 and 7.
Okay.
People 6 and 7 are admitted.
And then just along with those, I documented in my report the scans that were done prior to the self-checks. They both came back as passed and then documented in my report as such.
Thank you. No further questions, Your Honor.
Thank you. May this witness be excused?
Yes,
Did
Your
you
Honor.
want to cross-examine?
No further questions.
Thank you, Trooper. You can be excused.
Thank you, Your Honor.
Thank you. Any additional argument?
No additional argument. The people was rely on the trooper's testimony. He watched it self-check. The 2 printouts from the positive methamphetamine test were admitted into evidence. Your Honor, thank you.
Thank you. Today was the date and the time set for a preliminary examination. At the time of the examination, the burden is on the prosecution. They have to establish that they have sufficient probable cause that a crime is committed, and probable cause sufficient to charge you with the crime. So this is not a burden to be compared with their burden that they'll have to meet if this makes it to trial. Trial, the burden is beyond a reasonable doubt. Today, the burden is just more than mere suspicion that a crime was committed. Based on the testimony and evidence presented at today's hearing. And I'm the sole determiner of the credibility of the witness testimony. We had witness testimony today just from one witness, that's Trooper Luke Schaefer, testified that on the date of September 6, 2022, at the area at or near Larch and Cedar, which is in the city of Lansing, Ingham County, state of Michigan, that he initiated a traffic stop for a defective equipment and no insurance under the insurance code. He identified the defendant who's in the courtroom today, Mr. Terrell Marcus Robert, as the person driving the vehicle, that he showed a photo of his license on his phone. And officer testified that he observed a pint-sized bottle of vodka on the floor. It was unclear readily to his eye whether or not that bottle was empty or not. There was also a small plastic baggie that was seen in plain view, like near the gear shift. There's evidence here in People's Exhibit 4. It should be noted that the small plastic baggie was tied off a little bit to the top, and it was a cloudy residue on it. The officers asked or had the defendant to approach the front of the vehicle for further questioning. Officer decided that he would place the defendant under arrest. He stated for the no insurance, no license on person. He said he explained the open intoxication or open intoxicant statute to the defendant at the time. The defendant requested to speak to his attorney. The defendant was arrested. There was a search of the vehicle. The argument is whether or not the search was based on probable cause or whether or not it was an inventory search. The officer testified that he believed he had enough evidence to perform a search based on probable cause with that. Either way, he would have had to do an inventory search. He stated that he did do an inventory search and that that inventory report should have been included um, or uploaded with the evidence. With that being said, I do not believe that this is a situation where there was an unlawful search. So we won't address the motion to suppress. So you can deal with that at the circuit court. As to the complaint, there are 3 counts here as charged: controlled substance manufacturer or delivery of manufacture of methamphetamine is count 1. Count 2 is controlled substance manufacture, delivery cocaine, less than 50 grams. And then count 3 was a controlled substance delivery manufacturing cocaine, heroin, or other narcotic. That was the account charged in relation to the substance Utalon. The people are moving to dismiss count 3 and add count 4 under MCL 333.7401 2BA. As to the elements of unlawful delivery of a controlled substance, at the time of trial, the people would need to prove then beyond a reasonable doubt that the defendant intended to deliver the substance to someone else. Let's see here. Second, that the delivery must have taken some action toward delivering the substance, but failed to complete the delivery. It is not enough to prove that the defendant made preparations for delivering the substance. Things like planning a crime, arranging how it will be committed are just preparations. They do not qualify as an attempt. In order to qualify as an attempt, the actions must go beyond mere preparation to the point where the crime would have been completed if it had not been interrupted by outside circumstances. Should be noted there was testimony from the officer about a statement that the defendant made about selling the alleged narcotics and making about $400 that he would keep about $100. With that being stated, as to count 1, the court is satisfied that there is sufficient probable cause based on the testimony and the evidence as to count 1. There was testimony that there was 1 baggie that, or 2 baggies that tested for methamphetamine. Testimony from the officer was that the baggies were all 4 baggies that were recovered were true narc tested. 2 of them came inconclusive. However, the true narc, which I do have People's Exhibit 6 and 7 here, indicating that the self-check was passed on both of these checks and that they came back as testing positive for methamphetamine. So count 1 will be bound over to the circuit court. Count 2, it's controlled substance delivery manufacturing, cocaine, heroin, or other narcotic. That's the count being charged in relation to the controlled substance fentanyl. The other 2 unconclusive baggies were sent off to the MSP lab. Results here indicated in People's Exhibit 1 indicate that one of the baggies tested positive for 2.73 grams of fentanyl. That will be bound over to the circuit court for further proceeding. Count 3 was dismissed by motion of the people. There is a request to add a count 4 as to the substance butanol, which is a synthetic cathinol. We're requesting to add a count under MCL 333.74012BA, which is any other controlled substance classified in Schedule 1, 2, or 3 except marijuana, or a substance listed in Section 7212D1, which is guilty of a felony punishable by imprisonment of not more than 7 years or a fine of not more than 10 years or both. Based on the testimony and the lab report submitted in support of that testimony, the court will grant the request to add a count 4. And that will be added. All 3 counts will be bound over to the circuit court. Bind over date is going to be May 24th. You do not need to appear at the circuit court on May 24th. That's the date that the circuit court will get the file from this court, okay? Your next court date will be in circuit court, but it'll be a pretrial. Mr. Hess will be made aware of that date, and he'll keep you abreast of that, okay?
Thank you, Your Honor.
No problem. Bond was set at 7,510%. We addressing bond.
I don't have any motion regarding bond.
Bond will continue. Any additional matters?
No. Nothing on behalf of people. Thank you, Your Honor.
You're all set, sir.
Thank you, Your Honor.
What, Mr. Miller? What you mean? You didn't talk to him this week?
Oh, we talked.
Oh,
At length.
okay. But he just didn't want to come to. What do you mean? We're on the record in the matter of the people of the state of Michigan versus Louis Emmanuel Easley. File number 22-03541. Council appearance.
Brian Ring on behalf of the people.
And good morning, Your Honor. Stephen Wilson, that Mr. Easley, who is not here at this time.
Why is Mr. Easley not here at this time?
Thank you for asking. I have been speaking with Mr. Easley last week several times, and he gave me permission to speak to his court regarding his current situation. He's indicated to me that he is currently in Washington State. His father had him brought out there. He is getting some form of treatment that we are not entirely able to verify. And he is going to become a citizen of Washington State.
Oh, okay.
And he does have significant mental health disorders. I do have legitimate concerns here regarding how he got out there and his current relationship with his father.
Gotcha. Well, I do know that one of his bond conditions was he was not to leave the state without prior approval of the court. So he would be in violation of a bond condition. He didn't get prior approval. I don't see where I gave him the approval for him to leave the state. I approved for him to reside at the address of 6272 North Co, I think, in Luther, Michigan, with his grandparents. He gave me his grandparents' number. They said they would be responsible for it. Nonetheless, we'll issue a big warrant. Bond forfeiture. And if you make contact with them, Again, you can let him know that he has a warrant.
Already advised him that that was the likely outcome of today, Your Honor.
There's that. Thank you for your service. Additional matters for the record.
Nothing about it.
No.
You can be seated. We're on the record in the matter of the people of the state of Michigan versus Zachariah Richardson. File number 23-01306. Councilor Pitts.
Brian Ring on behalf of the people.
And good morning, Your Honor. Stephen Milton, I have Mr. Richardson, with present and staying my right at this time.
Today was the date and the time that was set for a preliminary examination. How are we proceeding?
At this time, we'd be seeking an adjournment off the basis of he was just arraigned on another felony matter. People would like some time to review both matters at the same time and potentially come up with some kind of an offer on both matters. He also has a pending misdemeanor matter. And I just made defense aware, and I just saw some messages between the victim and the first misdemeanor matter as well. So I just made defense aware, so we need some time to investigate that as well. And I just spoken for the victim in the felony matter for the first time today. I've been unable to get a hold of her, but she came in today and I have good contact with her now. So I'd be asking for an adjournment this time, Your Honor.
Thank you, Your Honor. Your Honor, I can't speak really to the misdemeanor case. I'm not representing him on that. As for this case, it's my understanding there's been no communications or anything, at least that I'm aware of, or that's been made aware to me. Your Honor, I will say that we were actually prepared, and the prosecutor offered a misdemeanor plea today. We were prepared to take that, and it was pulled last minute, kind of removing the opportunity to resolve this. It is my understanding as well that he's got new charges that he's being arraigned for today. I say new, but they're from quite some time ago, but the most recent charge is probably sitting on someone's desk somewhere, so we're trying to resolve all these things together. Because of all this, as frustrating as it is, Your Honor, we would ask to waive the 21-day rule, and at this time, request an adjournment. And I've been through this with my client. My understanding, he does understand what we're asking for today and would also agree with this adjournment. I would like to request or address, bond after this, Your Honor. Understanding I was just also made aware regarding this collateral case, this misdemeanor case, but thank you, Your Honor.
Okay, and so Mr. Richardson, you understand that you have the right to have a preliminary examination within 21 days of your arraignment?
Yes, ma'am.
Okay, and due to the circumstances largely involving there being multiple files and they're trying to maybe look at a global resolution, you're willing to waive the 21-day timeline so that this matter can be reset for another date?
Yes, ma'am.
Okay, anybody threatening you to get you to waive the timeline?
No, ma'am.
Okay, or reset your matter. We can do June 2nd at 8:30. June 2nd at 8:30. Any additional matters today?
None from the people, yeah, I think.
So the court said 9:30 or 8:30? 8:30. Thank you, Your Honor. Your Honor, I would just like to be heard regarding bond at this time.
Proceed.
Thank you, Your Honor. Your Honor, currently my client's bond is set at $10,000 cash surety in this matter. I have spoken to my client. He realizes that he does have bond regarding his misdemeanor case, which I believe is 1,010%, and he's likely going to be getting a bond in the upcoming case. Obviously, so what that would be. However, in this matter, Your Honor, as I said, we were in good faith ready to go forward on a plea today. To kind of have this pulled out from underneath us at this time. My client is willing to move forward, willing to resolve this case at a minimum. Due to this, Your Honor, I believe that my client could get a PR bond as well as a GPS tether that could assure the court that he's not going to go near anyone. Even with these charges here regarding potential stalking, I will remind the court that there was an original misdemeanor plea offer. I believe that it would be appropriate for a PR bond in this matter, obviously with GPS tether, with the no contact requirements. I do believe those things to be appropriate, Your Honor. Thank you.
Thank you, Your Honor. The people People's position is bond is appropriate as set, Your Honor. The victim is here today. This is the first time I have been able to speak with her. Yes, there was a misdemeanor offer in lieu of not having that opportunity to speak with her. I spoke with her today. She is very terrified of this individual. She's afraid that if he gets out, that she will end up dead, Your Honor. I have spoken with her for a little bit, what little time that I had to speak with her today. And there has been contact with the victim on I know the misdemeanor case is not here, but there has been victim contact on that.
It's different victims.
Different victims, yes, Your Honor.
Yeah, but this is a felony. It's
Yeah.
count one of home invasion first, aggravated stop, and MDOP, correct?
That's correct, Your Honor. And the new case is a strangulation on the same victim that is present today, Your Honor, that
And the allegation is in here is that he was gonna kill the victim.
that's correct, Your Honor.
So she's scared that he's gonna kill her if he gets out.
Yes, Your Honor.
Bond was set at 10,000 cash shorty. I think bond is appropriate. I don't see where GPS tether is added, but I'm gonna add GPS tether this. It needs to be GPS tether with victim notification. I'm gonna read her the no contact order. There's a no contact order in place for the protection of Tracy Terry. So you're not gonna have contact directly or indirectly with Tracy Terry. Do you understand that?
Yes, ma'am.
Okay, so that would also include jail calls or messages. You recognize that?
Yes, ma'am.
You do know also that the prosecution has access to those. So when they make that statement saying that this is a recorded phone call, it's not just semantics. It's recorded and they actually have prosecutors that are listening to that. You recognize that?
Yes, ma'am.
Okay, so you've been advised of the no contact order. Any violations of that will be a PA 53 violation. That's a bond violation. You understand that?
Yes, ma'am.
So if we have a bond violation, you could end up with no bond pending this matter. You understand that?
Yes, ma'am.
If you end up with a bond violation, you can end up having to serve 93 days in jail or pay a fine of $7,500. You understand that?
Yes, ma'am.
Or you could have your phone privileges revoked while you're sitting in custody. You understand that?
Yes, ma'am.
Okay, you don't want that.
No, I don't.
Agreed. Okay, so I don't think we'll have any issues. So bond will continue, 10,000 cash shorty. We're adding GPS tether with victim notification. Not to be within 1,500 feet of wherever the victim lives, works, or goes to school, does her grocery shopping, does her laundry, gets her card serviced. Essentially, wherever she is, you can't be within 1,500 feet of that, okay? Do
Yes, ma'am.
you have any questions about the bond condition?
It's still a 10,000 cash surety.
Oh, absolutely.
Okay.
Any additional matters?
Just for my clarification, the no contact includes any sort of communications, is that right, Your Honor?
All the types,
Emails or,
all the types, like there's no possible types.
I would not.
Even if you like created a type of communication that doesn't exist now, that will be included,
Yes, ma'am.
okay? No problem. Did you see Miss Armistead yet? She's not here.
She, when I talked about, just before you came on the bench, she said she was on Kalamazoo, and I explained to her that he was on Chino.
Gotcha. Oh, so she should be here shortly. She knows who we are. On the record in the matter of the people of the state of Michigan versus Brett James Garotny, file numbers 22-3378 and 23-00399. Council appearance.
Fran Ring on behalf of the people.
Good morning, Your Honor. Jared Austin appearing on behalf of Mr. Karatny. He is present to my right, in the jury box.
Okay, and Mr. Garotny, today was the date that we reset this matter. If you were looking for counsel, correct? And have you been able to obtain counsel?
First round was gonna pay for it, so
The attorney you wanted to pay for passed away?
No, my fiance was gonna pay for it. She passed.
Oh, I'm sorry to hear that. Your fiance passed away. You did mention she was battling cancer, correct? Okay. Okay, my condolences to you on that. I'm sure that's difficult to manage, especially given your current situation. How do you intend to proceed though with this situation? Are you going to proceed with the public defense? Okay. You have Mr. Austin, I think, on one. Are you on both of these? So, Mr. Austin?
I'm on the felony file, Your Honor. Ms. Donnelly represents all the misdemeanor files. I learned those were set for today as well, so I can go for her on those
Okay.
matters as well.
Sounds good. Okay, how do you want to proceed?
Your Honor, could counsel approach?
You may. Okay, so there's a request to adjourn at this time on both files. How much time do we need?
That's you.
Your Honor, I would think that a month's time period would be sufficient.
June 15th. 10 a.m. June 15th at 10 a.m.
That will work, Your Honor.
Setting both of those files for the date.
Yeah.
Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Nothing further, Your Honor.
We're all set today, Mr. Cratney.
I have the beautiful blue suit that I came to work in yesterday.
Right now, you have had a whole conversation for 50 hours.
I know. I forgot. I was like.
Yeah,
no.
well, that's not my fault. We're on the record in the matter of the people of the state of Michigan versus Leasia Armistead, file number 21-02870FY. Councilman Harris.
Brian Ring on behalf of the people.
Good morning, Your Honor. I want you to turn it for Ms. Armstrong.
Okay, Ms. Armistead. I have a few files here. Let me first do this one. File number 23-01169. That's actually the people of the city of Lansing request Ms. Leisure Armistead, you were supposed to appear for arraignment on the 8th at 8:30. You did not appear. Why is that?
I didn't get the mail for that. My mailing address that I have right now is my sister's, and she's in the middle of like, she just moved. So I think they like had sent it back or something like that. I'm not sure. Every other one I have got.
What's your address?
1134. That's the one I have to change it.
1134 Littleway?
Yep.
That's where it went. And no return mail came here. Nonetheless, you remember getting a citation on April 10th, 2023 at 2:34 in the morning for a driving ticket. So I have a citation here that alleges that on or about April 10, 2023 at 2:34 in the morning at East Kalamazoo and South Home Street, City of Lansing, Union County, State of Michigan, that you allegedly were stopped and provided you furnished false information to the police officer. You were also given an expired meter citation. And so the citation, when you failed to appear for your first court appearance, that was a civil infraction. So it was defaulted. You owe $96 on that.
I think that time was when I just went to jail. He didn't give me no citation or nothing. He just told me I was going to jail for that for work.
You said you just went to jail.
Yeah, like I had a warrant for a while, and then I got pulled over on Kalamazoo because they said I didn't use my blinker.
Okay, well,
didn't
without you getting into any details that may be used against you, there was a citation that was issued, because there's a copy of it in my file. Construe your statements as a motion to withdraw default on the default judgment. And so you'll get a hearing date on that. As to the furnishing false information using a vehicle, you have the right to proceed to a trial in that matter because it's a misdemeanor. It's punishable with the maximum penalty of 90 days in jail and or $500 in fines. You have the right to be represented by counsel. If you cannot afford to hire an attorney, you can have court-appointed counsel represent you at the expense of the public. My understanding that you do have public defender representing you at this time in other files, correct?
Yes.
Okay, so I'll see if you need an updated intake, but I'll note here that you're requesting court-appointed counsel. You have the right to remain silent. Anything that you say and anything that you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. You have the right to have a jury trial. At the time of trial, you have the right to have the city bring sufficient evidence to prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt at trial. You have the right to confront, see, hear, or question any other witnesses that the city calls. You have the right to call your own witnesses or present evidence at trial that you believe would further defense of this charge. You understand your rights so far? You have the right to have them prove each element beyond a reasonable doubt. We'll give you a hearing date and the court will enter a plea of not guilty on your behalf.
It'll be May 23rd at 9:30.
May 23rd at 9:30 is your hearing date on that. You have any questions about the furnishing false information and the expired meter? Why is that in the actual? I'm not understanding why they're attaching expired meter into this file. This should not be, here. This is a separate file. This was actually an expired meter. This was not in a citation that you received. The allegation here is that you had an expired meter from 2021. Failure to pay your parking ticket. And so because of that, there's been fines and costs attached. And you do owe that $96. That was not a default judgment. I don't know why they put that in this file. When can you make payment on that?
I can pay something right now.
How much you gonna pay today?
Like half.
When are you gonna pay the balance? When will you pay the balance?
In a couple days. Tomorrow.
I'll look at in the file on that one. Then these other files here. File number 21-02870, which is the felony file, but then I also have two misdemeanor files, 22-01267 and 22-03506. You have PA 53 violations, those are bond violations there. The allegation that you violated the terms and conditions of your bond. I have a report here from the Lansing Police Department that alleges that on May 7th, 2023, at approximately 2:00 in the morning at the area of 610 West Ottawa Street, City of Lansing, Ingham County, State of Michigan, you violated the terms of your bond by engaging in assaultive or threatening behavior. Just making sure I don't leave it the same violation. There's also the violation is that you engage in assaulting and threatening behavior, and that you also violated by committing a crime. I don't know if it appears that there may be new charges that may result from the police report attached to this file. So you have the right to have a contested hearing of the bond violations. You have the right to be represented by counsel. And during that bond violation hearing, you have the right to have the prosecution bring sufficient evidence to prove whether or not you violated your bond.
That's when I can bring proof, like if there was a.
You have the right to submit a defense at the time of the hearing. That is correct. If you're found to be in violation of your bond, ma'am, your bond could be revoked while you navigate the criminal justice process with these files. You could end up sitting in jail. Do you understand that? You also, is that a yes?
Yes, ma'am.
Okay, you also could end up with a sentence of maximum penalty 93 days in jail or a fine of up to $7,500 in fines. Do you understand that? For the purposes of her arraignment on a bond violation, counsel, how does she want to plead? Court went to plea of not guilty, and we're gonna set these for hearing. We can just do on the day of the pre-trials, May 25th. It's May 25th for you for hearing.
What day?
May 25th at 9:30.
That's fine.
We'll do May 25th at 9:30 for hearing. And also remind you that you have pre-trial on one of these files, the assault and battery, May 25th at 9:30, and then you have actually a pre-trial on two of those at May 25th at 9:30. Then you have the new file. That's going to be a pre-trial on May 23rd. We have two pre-trials on that date. However, on this date, you need to appear in person, okay? Do you have any questions? Bond will continue at this time. Any additional matters?
We reset the prelim votes.
Has to be reset. I can't bind the case over with the pending PA 53.
And that was set for the, did you give a date for that?
We'll do May 25th at 9:30.
Nothing else from people. Thank you, Ron.
Thank you. You're all set, man. We'll get you a copy of your notice.
Thank you.
You're welcome.
Can you take that file to one of them to do the warrant so I can schedule her for trial?
Have a good one. Is that everything? Oh, she wrote.